India has faced a string of arbitration by investors including Dosha Telecom, Nissan Motors, Vodafone and Cairn Energy over issues ranging from retrospective taxation to payment disputes. Although the Narendra Modi government has repeatedly spoken against its predecessors unleashing tax terrorism, it has also promised to avoid taking such steps without reversing the decisions. Strong states grow stronger by putting limits on their own powers. Weak states become weaker by descending into the arbitrariness. India has chosen to be the latter. Well, that's the message being given to New Delhi by an international arbitration tribunal in The Hague. In a fresh setback to the government on retrospective taxation, an arbitration panel has unanimously ruled in favor of Cairn Energy, holding that the centre has failed to uphold its obligations under the UK-India Bilateral Investment Treaty and international laws in seeking tax payments of Rs 10,000 crores from the company for its business reorganization in the country. The panel threw out the Indian government's $3 billion tax demand against Vodafone Group, finding it to be in the breach of fair treatment under the country's Bilateral Investment Protection Pact with the Netherlands, and they awarded the cost to the British Telecom. This ends a decade-old saga that tarnished India's reputation among foreign investors. Rather than appealing the decision, Prime Minister Narendra Modi's administration should accept the defeat, honor the award and move on. While much of the blame for this mess belongs to the previous Congress-led coalition, Team Modi had 6 years to end the dispute. Ending the tax terror was also his party's promise in the 2014 election manifesto that brought Modi to power. If anything, reckless expansion of the state's power, both in the economy and broader society, has become the norm since then. One hopes that this becomes a moment when Indian politicians of all hues will come together to say, yes, we bungled. We should never have amended the tax laws retrospectively to go after Vodafone. It cost us more in prestige than we could hope to win. In May 2007, Vodafone had bought a 67% stake in Hutchinson for $11 billion. This included mobile telephone business and other assets of Hutchinson in India. In September that year, the Indian government for the first time raised a demand of 8,000 crores in capital gains and withholding tax from Vodafone, saying the company should have deducted the tax at source before making a payment to Hutchinson. Vodafone challenged the demand notice in Bombay High Court, which ruled in favor of the Income Tax Department. Subsequently, Vodafone challenged the High Court's judgment in the Supreme Court, which in 2012 ruled that Vodafone Group's interpretation of the Income Tax Act of 1961 was correct and that it did not have to pay any taxes for the stake purchase. The same year, the then Finance Minister, late Pranab Mukherjee, circumvented the Supreme Court's ruling by proposing an amendment to the Finance Act, thereby giving the Income Tax Department the power to retrospectively tax such deals to go after the merger and acquisition deals all the way back to 1962, if the underlying assets was in India. The act was passed by the Parliament that year, and the onus to pay the taxes fell back on Vodafone. The case had by then become infamous as the retrospective taxation case. The vindicativeness was targeted at Vodafone, but also ensnared UK's Cairn Energy, which in 2006 had transferred ownership of its Rajasthan oil field, the country's biggest onshore discovery in 2 decades, to Cairn India Limited, to prepare for the local unit's initial public offering. What's worse? What can be possibly the worst case? The $4.3 billion final assessment order for the Cairn Energy came in 2016. By that time, Modi's government had been in power for almost 2 years, giving it ample time to fulfill its promise of a non-adversarial tax regime. But Cairn India disputed the levy. New Delhi expropriated its share in Indian billionaire Anil Agarwal's Vedanta Limited, into which Cairn had merged the Indian unit. The government pocketed the dividends and then sold the stakes. The application of the retrospective tax took a farcical turn when around the Christmas holidays of 2016, a month after a draconian ban on 86% of the country's banknotes, India began to instruct fund managers to withhold and pay taxes when investors made a profit selling units in offshore vehicles that had half or more of their investment in Indian securities. Thankfully, this impractical plan was dropped after it was pointed out that it would kill the India-focused funds industry. After the arbitration ruling, the Cairn Energy's share almost saw a jump of 13% in London Stock Exchange. Investors have reason to be hopeful. After all, it turned out that even India's own nominee on Vodafone tribunals rejected India's claim. For Vodafone India's unit, though the victory is pyrrhic, it's now the victim of different overreach, a life-threatening $7.8 billion demand for past use of airwaves and AGR. In a way, it's a good news that data irregularities forced the World Bank to suspend its ease of doing business survey, which saw India zoom past 79 nations between 2014 and 2019. The reality on ground may be very different, although Modi's government did not invent the capricious Indian state. But it hasn't lessened uncertainty or cut red tapeism, neither for small startups nor for large global investors. Appealing the Vodafone and Cairn arbitration award will only mean that it's once again failing to learn its lesson.